Hello and welcome back to Maine Justice. It is Tuesday morning, June 2nd. I'm Andrew Weissman, and I'm here with the great, wonderful, terrific Mary McCord.
Well, with that intro, I mean, we should just mic drop and be done.
Okay. Well, anyway, thanks for listening. This has been an insane week because I know you've been incredibly busy. I've been incredibly busy on book stuff. I know we're going to actually talk about an op-ed. I am dying to hear. Mary, we have not had a chance to talk about it.
No,
so
we
I'm
haven't.
really dying to hear what you think about it because this falls into as you can tell, Mary, I am very much thinking about systemic reform issues.
Yep.
Because it's like,
as we all should be.
Yeah. I mean, I know lots of people are thinking about that sort of hopeful because it's like, if we get out of this mess, what we can do to build the norms back. And this is one area I know you and I have talked about is what restraints we want on our former selves. Anyway, there's so much that we want to talk about because it's been a fascinating week. There's been really, it's hard to say good news, but it is because we've seen so many examples of principled behavior in all sorts of walks of life. With that lead in, Mary, how are we going to divide up our time together?
Yeah, well, that's a perfect segue to we're seeing, and this is not a new theme, judges pushing back, right? Judges pushing back. They've had enough. They are, I think, concerned about the impact of what this administration is doing in court on the integrity of the judiciary, the function of the judiciary, the ability of the judiciary as a branch of government to do its job and do its job effectively. And so we will start there. We will start with the $1.776 billion slush fund and the judge in Florida who had the case that Trump had brought against the IRS about the leaks of tax information, who had dismissed that case upon Trump's motion to dismiss and has now ordered briefing in that case on whether, in fact, that whole case was essentially a fraud on the court in order to establish a case that could then be settled with the formation of this fund. And let's not forget the release of Trump and his family and his businesses from kind of any liability up to the point when the case is dismissed. So this is huge news. We'll dive into it. But that's not all.
And by the way, Mary, I've been watching some of the news since yesterday about the news of what I call the sort of potential flushing of the slush fund case.
Nice.
As our producer said before I started, say that 3 times fast.
Yeah.
But I think this is one where you and I are going to have an interesting take on that that's a little bit deeper than the sort of initial reaction. So I'm dying to talk to you about that.
Yeah. Yeah.
What else?
And in that same vein, and this did not get nearly as much attention as maybe it should have, although it was a very short order, Judge Mehta, who had presided over the Oath Keepers seditious conspiracy trial, had issued the sentences in that case. The government has moved to dismiss those indictments, I think setting up those former defendants to either get money from the slush fund or, if that's no longer in existence, to sue the government for funds. And Judge Mehta has said, hold on a minute, I have the ability to rule on the appropriateness of this dismissal, and you've given me no reasons whatsoever. Brief up some reasons.
Perfect bookend. It's interesting that it didn't get play because it is such a bookend to the order out of Florida. So we're going to talk about those two. But what else?
Yes, then we'll move on to something that frankly seems to be making Donald Trump even sort of crazier than the whole slush fund debacle, which is Judge Cooper out of the district court here in D.C. ruled against him in the Kennedy Center case, saying, guess what? You can't change the name of the Kennedy Center just on your say-so. Board of trustees all pretty much appointed by and loyal to Donald Trump. There's a statute that says the name of the Kennedy Center is the John F. Kennedy Memorial Center. It's a living memorial to the former president, and you can't change that.
It's a memorial to the assassinated president.
That's right. And you can't change the name without Congress.
Some of the arguments that the administration made, I can't wait to highlight those because they're jaw-dropping in what we would call in New York, their chutzpah.
That's exactly the word I was thinking of. I won't get into that more now in the intro because we have this tendency to start to flesh out the details in the intro. So we're going to wait. We're going to restrain ourselves, Andrew. Restraint.
Our producer would be so happy.
I know. Look at me, keeping the trains moving, trying to. And then we will close out also in another important order from a federal judge in Alabama in the criminal case against the Southern Poverty Law Center, ruling on a motion that the SPLC, the Southern Poverty Law Center, had filed to correct false statements in the record. And basically, after the government self-corrected, the judge says, I don't need to rule on this now because the government corrected its false statements. But let me talk a little bit about the obligation of a prosecutor.
This is one where they won and lost.
That's right.
It's like you read this order and I'm like, I'm sorry, who won?
Yeah, exactly.
The government technically won, but not really.
But only after it basically corrected itself.
Corrected itself.
Oh, those lies that we told?
After they had to admit that Todd Blanche lied through his teeth publicly on Fox News.
Yes.
And got called out for it. I think the theme today is hand cookie jar, because that's one where Todd Blanche had his hand caught in the cookie jar and got smacked down. And now taking it to our first topic, which is someone's hand getting caught in the slush fund cookie jar and got caught for it. So let's talk about the slush fund. And I think to set it up, I mean, everyone knows that there was this $10 billion lawsuit, that it was quote unquote settled. Thing one was the idea that there would be a $1.776 billion quote settlement. Thing two was the hullabaloo about the money going to people who are not victims at all, but are convicted criminals, including convicted criminals who had assaulted police officers. And thing three, which we had talked about also, is this idea of this vast civil release that only Todd Blanche signed. Now, the judge has now reopened the case in the sense that the judge wants to hear from the parties. And remember, the government has not actually filed, and nobody has appeared on behalf of the government. And the judge is like, I want to hear from the parties about essentially whether this is a fraud on the court. And here is where there was a brief by a number of former judges. And just so people understand, the theory that these judges had raised was the government here did not just enter into some private settlement. Donald Trump brings this lawsuit while he is president saying, I want the sort of veneer of a claim. I want the veneer of a lawsuit. And then we're going to have a veneer of a settlement. So it gives it sort of the imprimatur of being kosher. The idea is that Donald Trump and DOJ, if they're acting collusively, they wanted this idea that this is all part of a court proceeding and that this is a valid claim. And this is proceeding as part of a real settlement by adverse parties, so that it gave this sort of fig leaf of looking like what a real plaintiff would do with a real defendant. And that was sort of what these former judges were complaining about, saying they're bringing the court into this so that they can give it a sort of air of and a sense of legitimacy.
Right.
Mary, over to you.
And so the posture here, because I think it is important, and listeners will remember back when the judge granted the motion to dismiss under a rule that basically says when the plaintiff in a case here, Donald Trump, moves to dismiss a case before the defendant, here the IRS, through the Department of Justice, ever responds at all, then that is something that can be done without the court's approval, right? So the court had dismissed, and you and I talked about, gosh, if I were the court, I wouldn't have dismissed so fast. I would have said, given the way this tends to look and the fact that I had already asked for briefing on whether the parties were truly adverse because Trump had essentially sued his own executive branch, and the question for the judge in that case, and that question she had sought briefing on, was whether, in fact, there was true standing. There was a true case or controversy because parties have to be adverse. And in their timing of dismissing before that briefing raised already red flags. And I thought at the time, why doesn't she order more briefing on whether this isn't some sort of fraud on the court? Well, that's exactly what these judges said. They said, you have the ability under Rule 60 of the Federal Rules of Civil Procedure to reopen a matter when it appears there's been a fraud on the court. And the language they used to describe what happened, I think, is just, really good in setting this forth. So they file this right after it's been dismissed, but they're still able to file it because they're moving to have the court reopen. They say the parties have used this lawsuit, which was never an adversarial proceeding over which the court even had jurisdiction, as a means to allow a quote unquote commission controlled by the president to dole out $1.776 billion in taxpayer dollars without constitutional or congressional authority to do so, and to confer unlawful private benefits to the president and his family by purportedly prohibiting the United States from prosecuting any and all claims against them. And the parties have plainly tried to shield this conduct from necessary judicial scrutiny by short-circuiting this court's inquiry into whether the lawsuit is in fact an actual case or controversy by filing the Rule 41A notice before they announced the settlement, clearly in hopes of preventing the court from ever completing that inquiry, which, if it comes out against the parties, will undo their collusive settlement, right? They say, you've got the power to do this. And the court very, very quickly, I was
Agreed.
surprised, frankly, agreed. The movements explained that although there was no settlement of record, public documents and announcements indicate the dismissal of this case was premised on a purported settlement between the parties that these non-party movements, meaning the judges, claim is a product of collusion and is itself a fraud on the court. The court then goes through another rule and says, even if under the rules the president could dismiss this case and I don't have jurisdiction over the original case, I still have jurisdiction as a judge to have an inquiry into whether sanctions should be imposed under Rule 11, another rule for any type of misconduct or fraud on the court. So here's what she has asked for very specifically. By June 12th, she wants a response by Donald Trump and the plaintiffs to this motion of the judges detailing their position on three things: the charges of collusion and whether the parties are truly adverse; two, the assertion that the dismissal in this case was premised on deception by the parties; and three, the question of whether the case should be reopened because the court was the victim of fraud. So it's in that posture, right after this is issued, that we start hearing rumblings that maybe Donald Trump is just going to walk away from this slush fund.
Yes. And that's where I think there's so much going on here. So Axios broke this story, and now it's been picked up in other newspapers confirming it, that it may not go forward. And a couple things. One, in the Axios story, there is a whole hot potato of who's going to take the blame for this. And the Axios story ends with some unidentified person from the White House saying it was DOJ and we had nothing to do with this. We were blindsided by it. Mary, how can the White House be blindsided when the head of the White House, the president, is the plaintiff?
It's the plaintiff. I'm not buying it.
It is so stupid because that quote of "we were blindsided" is an exhibit A, if you need more exhibits, to the judge's concern about fraud and collusion. It's like, it's not possible for them not to be involved. Are you saying, really, you're saying Todd Blanche settled this with nobody? Or that somebody was representing the president but didn't? I mean, this is insane.
Because we're talking about a settlement, right, between the parties to this bogus lawsuit. But still, one of those parties is Donald Trump.
So somebody from the White House obviously wanted to blame DOJ, and they didn't think about the fact that it's nonsensical. They're obviously concerned because the president is not going to say it's my fault. The president's going to blame it on someone. Todd Blanche is, to me, the person who's going to hold the bag. And he is, to me, it's going to be, as they say in Washington, circling the drain. And so there's going to be a whole blame game of, which, by the way, is, to me, going to be falsehoods about this because it's obviously the president. But to sit there and say that the White House was blindsided by, really, you created a fund of $1.776 billion and you gave a release of civil liability, and all of this happened in an alleged settlement of Donald Trump's personal claim for $1 billion. I mean, it is laughable.
10 billion, just to be clear.
Yes. Sorry, a 10 billion, and to get about 2 billion of that, which he then decides how he wants to spend it. So that was sort of thing one. Thing two is the reports don't say anything about the
release,
the general release. Exactly. And this is where I knew you and I would go straight for the artery. To sit there and say, let's just do a do-over and let's just sort of take this away and don't worry about it. There's still that civil release out there.
Yep.
And so the judge has authority. And by the way, even if the whole case went away, the judge still can look at Rule 11. You don't get to attempt to
That's
file in
right.
the court, and then the court says, oh, wait, now there's nothing in front of me. The judge still has authority, even if thing one, thing two, and thing three goes away. But there's nothing in the Axios story about thing three, the civil release. So the court still has the ability to get to the bottom of this. This stinks to high heaven because not only do you have this effort to create a bogus slush fund, but you now have, as we know from Watergate, a cover up of what happened where everyone is going to be scurrying around trying to not be the person who Donald Trump blames.
Yeah, you're exactly right. And there's another aspect here. I agree with everything you said. Surprise, surprise. I think Congress has been more upset about the slush fund in many ways, at least on a bipartisan basis, than the release. And so I think that there's this thought probably among many members of Congress, especially the Republican members of Congress, that, whew, okay, this takes this hot button issue up our plates. We don't have to worry about the problem of this slush fund potentially paying out.
We don't have to stand up to the president, right?
Right, exactly. But that doesn't get rid of everything because this release, remember, this is the thing we talked about last week with our listeners. This isn't just about ending a tax audit. This says anything, any investigation, examination, prosecution, claim that the U.S. government could have against Donald Trump, his family, his companies, anybody affiliated with his companies, that there was the predicate for doing now, even if nobody had done that investigation, is here and forever abandoned and given up and released. And so that is basically the civil equivalent of a pardon, right? And that is outrageous. And
Absolutely.
that is something that getting rid of the slush fund doesn't do anything about that. And that is why, like you said, this judge still should be looking into this because I think that's one of the most outrageous. Both parts of the settlement were outrageous, let's be clear. But that's a very outrageous part that Congress should not just look the other way and be like, oh, well, we don't worry about that because that's pretty significant.
Why don't we take a break? And when we come back, I wanted to suggest and get people thinking about systemic reform. You can react to what's currently going on, but there's a way to think about what's going on in terms of what could Congress, wake up, Congress, do so that we aren't in this situation again under any presidency.
Sounds good.
Welcome back. So, Mary, one of the things that you and I have been seeing is that there are some people in Congress, and I'm talking Jamie Raskin, who are thinking about this in a systemic way. And one of the ideas is for Congress to say that the president or people acting on his behalf or his interests cannot bring a civil suit against the government while the person is president, so that you don't end up in this situation where the president or people suing on his behalf are on both sides of the equation. By the way, who thought you needed this law? Because it's a little bit like don't stick a sharp pencil in your ear. You never thought you needed it because you never thought somebody would do it. But this is one where I really do think Congress could remedy this situation. Let the executive bring a lawsuit saying, no, I have the power to always sue in my personal capacity. But I don't think they would because this is, remember, a personal lawsuit that they could say, yeah, you can do it. You're just going to wait until you're no longer the president. So it's useful to think about what it is that you would want. When I say you, I'm talking to our listeners. What would you want to see Congress do here so that this situation doesn't arise?
And it's a situation that, Trump himself admitted was like suing himself, and he would be responsible for settling against himself. And that kind of self-dealing and conflict, it honestly should be pretty bipartisan that we don't want to see this, because if Donald Trump can do this when he's a president, so could somebody else. And I always hate that argument because I think what he does is so unprincipled that I want to think any future president of either party would not do the things that he does. But the fact is, folks do have to think about—
He's broken the model, right? He's broken it.
How do you go back?
While we're at it, I'm sure there are people listening. And meanwhile, people in Congress should not be able to invest in the stock market and trade on information. I mean, you could go on to expand it, but this is one where at least this can be done. You would think there would be enough bipartisan support for this. Just, it's kind of a no-brainer.
One would think.
So this is a perfect segue to something you teed up to Judge Mehta in the DC courts. What's going on there?
So, this is another in the continuing saga of rewriting history and rewriting the history, particularly of January 6th. And we've seen that the Oath Keepers and the Proud Boys had appealed their convictions up to the DC Circuit. The circuit was weighing in on those when in came the government and said, we'd like you to just dismiss this appeal and remand the cases back to the district court because we, the government, intend to go into the district court and seek a dismissal of the underlying indictments. Mind you, this is after trials, after convictions by jury, after sentences were imposed. Now, granted, those sentences were commuted by Donald Trump as part of his mass pardons and commutations, but still, a commutation means there is still a conviction there. And so the DC Circuit had said, okay, we will remand this for the district court to consider such motions should they be filed. And the government has come in with the consent of the defendants, of course, because why would they object, and say, we want to dismiss the underlying cases. And here's the reason they give. Okay, are you ready? This is going to take me a while to read it.
I love the snark,
Yes.
Mary.
Yeah. The government has determined in its prosecutorial discretion that dismissal of this criminal case is in the interest of justice. Full stop.
Can I just contrast this with what Judge Mehta said when he sentenced Mr. Rhodes to 18 years in prison? He said that he found that Mr. Rhodes was an ongoing threat and a peril to this country, to the republic, and to the very fabric of our democracy. That is what the judge found in sentencing Mr. Rhodes to 18 years. That's just one example of the type of people that we're talking about who already have received a commutation, but now the government wants to just erase it completely so that the commutation is not a full erasure.
It just ends the sentence. It just cuts off the sentence right at the date of the commutation. You get released from all of your obligations under your sentence, whether it's jail time or other types of supervised release or what have you.
But the case and the criminal conviction
Right.
is still there. This is just the government saying, we want to just completely eradicate this so there's no criminal record at all. And as you said, a precursor to show me the money.
That's right. Because this happened with Michael Flynn, right? Stephen Bannon is trying to get the same thing. Exactly.
And obviously, when we're talking about people who would be the leaders of the Oath Keepers and the Proud Boys, I mean, we are talking about in a really, really different category than people who participated, but in a much, much more minor
That's
way
right.
on January 6th.
And even with that said, Andrew, even on the people of lesser culpability, going back after they've either pleaded guilty or been found guilty by a jury or a judge and saying, we want to dismiss the whole thing, that's still,
Very-
totally.
Oh,
Just
oh,
wrong when there's
absolutely.
nothing undermining the basis for the conviction, right? This is really gamesmanship, and it's using and abusing the court system, which is why I think, we're seeing some pushback. So what Judge Mehta says is, and this is where there's a contrast with the civil rule we just talked about that
Yep.
says a plaintiff can dismiss a case before the defendant answers without the judge's approval. A criminal case cannot be dismissed by the government without leave of the court, which means the court has to bless it. There's a lot of really open questions here because, and particularly post the immunity decision that basically says that the president has complete control over prosecutorial decisions of his Department of Justice, that this is a unique executive branch function. And so
But here the case is over, right?
that's right. I'm just saying this is not without open questions about could a judge actually prevent a dismissal. But still, the rule says with leave of court. And what Judge Mehta has done is he's pulled from existing DC Circuit precedent that says this gives a court a role in the dismissals. And in the exercise of its responsibility, the court will not be content with a mere conclusory statement by the prosecutor that dismissal is in the public interest, but will require a statement of reasons and underlying factual basis. And there, Judge Mehta was quoting directly from a DC Circuit case saying that a district judge can require reasons. The court does not have the primary responsibility, but rather the role of guarding against abuse of prosecutorial discretion. So what he has done is he has ordered the government, he says the government's motion was insufficiently detailed to allow the court to follow these principles that the DC Circuit has laid down. The government has offered little more than a conclusory statement. And so the court says the government shall supplement its motion to dismiss by this Friday, June 5th, with some underlying factual basis, some information that the court needs to determine whether the reasons that the government provided for dismissing the case are substantial and to guard against abuse of prosecutorial discretion.
And so what's interesting here is if the government comes in and says we're doing it because these people were the victims of prosecutorial abuse under the Biden administration, in other words, all the stuff that we hear Donald Trump spout from the bully pulpit, it's going to be bully pulpit spouting meets reality. So that you're going to have fact and fiction, and you could easily have Judge Maida say, well, I sat through the trial. I've sat through multiple cases, and that's not what happened.
That's right.
So what you are telling me is the reason is not factually predicated.
I think you could also see Judge Maida appoint an amicus to brief the other side, since right now this is an unopposed motion. And that is something that Judge Sullivan did years ago when the government moved to dismiss the Michael Flynn case and get some briefing to take the other position. So we will follow this closely because, again, this is another effort to rewrite that history. I mean, this is also where I think Congress, this is why they were so opposed to the slush fund, because they did not want to see it go to people who engaged in violence at the Capitol. They were there. Many of them were there. They know exactly
victims.
what happened. And they don't like that effort to rewrite history. And the judges don't like it because the judges handled almost 1,600 cases. They handled multiple trials. They heard the evidence over and over and over again. Many of them in sentencing defendants were very clear about how wrong this was and how efforts to pretend like it is something other than what it was are efforts to rewrite history. So it really, I think, this issue of January 6th continues to be something that judges and even members of Congress are not quite willing to go where the president wants to go there.
So on the theory of rewriting history, shall we talk about staying with DC and DC judges? Because another federal DC judge, Judge Cooper, wrote his decision about the Kennedy Center because Donald Trump had it summarily renamed as the Trump Kennedy Center and put his name first, which, by the way, he argued to Judge Cooper, no, I wasn't really changing the name. It's still a memorial to John F. Kennedy. I'm just putting my name first.
Yeah.
Above it.
It's kind of like changing the Bureau of Consumer Financial Protection to the Consumer Financial Protection Board or something like that. And it's like, no, it's not.
Right.
Those are the same words in a different order. It's not that way at all.
Right. The arguments were, as he said, laughable.
Now, in fairness on the renaming, this doesn't make it any less bad, but there was an intermediate step there before it wasn't Donald Trump himself renaming, right?
He put his board in and said, I want the name changed.
He got rid of trustees of the Center's Board of Trustee, appointed himself a trustee. Then this newly reconstituted board elected him chair, replaced the president, and then they voted to rename the Kennedy Center and also voted to strip ex officio members like the Congress member who is the plaintiff in this case of any voting rights. And in fact, on the day of the naming, this is such an incredible story. On the day of the vote on renaming, she was participating remotely in this, and renaming had not even been on the agenda. And when the renaming issue came up, she went to unmute herself to object and register her objection to the renaming, and she was muted by the administrator. So she was not even able to speak, register her objection, or vote. So Judge Cooper, to get to the bottom of it, said on both of those issues, the statute doesn't allow for that. The statute established the name. And this is where I think your point of going back in history is important, right? He goes back to 1962 when President Kennedy and the First Lady, Jacqueline Kennedy, presided over an American pageant of the arts at what was then the National Cultural Center. It had people like the poet Robert Frost, singer Harry Belafonte. And at that point, I loved this line, the then 7-year-old cellist, Yo-Yo Ma.
I
7
know.
years old.
I know.
And, he talked about how important the arts are, how important culture is. There's so many things that I think governments, and I can tell you, I feel this way when you're so busy in your job, whether as a prosecutor or national security, that sometimes you feel like the arts aren't important, that culture is not important because we have these other important things. And right now, I feel this way often, that I don't have time to go appreciate art because every day there's some other terrible thing happening that requires a legal response and analysis. But President Kennedy was right. If we don't have the arts, if we don't have music and theater and dance and literature, we lose culture. I mean, that's what the history of the world goes back to, cultural things. And that's why ultimately Congress decided to make this the John F. Kennedy Memorial Center for the Performing Arts and a living memorial.
I couldn't agree with you more. I just want to read this because I reacted the exact same way. Let me read the quote from the judge, and this is from President Kennedy. Art knows no national boundaries. Genius can speak in any tongue, and the entire world will hear it and listen. Behind the storm of daily conflict and crisis, the dramatic confrontations, the tumult of political struggle, the poet, the artist, the musician, continues the quiet work of centuries, building bridges and experience between peoples, reminding man of the universality of his feelings and desires and despairs, and reminding him that the forces that unite are deeper than those that divide. I am certain that after the dust of centuries has passed over our cities, we too will be remembered not for victories or defeats in battle or in politics, but for our contribution to the human spirit.
Can't say it much better than that. Like I said, I get caught up in the daily tumult, right? And so I try to remind myself to occasionally think about something else. But that is why Congress did what it did. And what Judge Cooper goes through in 94 pages, because the statutes here are complicated, is not even the right word. There's just a lot to dig through. What is the role of a trustee? Because the plaintiff, as I said, the Congress member who's the plaintiff is a trustee, and trustees have a fiduciary duty to the trust. And, the Kennedy Center is established by this trust. So he goes through what he calls the Kennedy Center's organic statute. And what that word means, organic, there means the foundational statute whereby Congress created this living memorial to John F. Kennedy. And he ends up concluding three things, because three things were challenged. One is that he says that Kennedy Center's organic statute makes crystal clear that the center is to be named for President Kennedy, and it cannot bear any other formal name or public memorial based on the board's unilateral say-so. Congress gave the Kennedy Center its name. Only Congress can change it. Therefore, the name Donald Trump has to come down off of the outside wall, and the renaming that has gone on the website and everything else has to change. Second, he says the Congresswoman wins on the voting rights issue, that the center's, again, organic statute made no distinction between general and ex officio members, because she's an ex officio member. She gets her right to vote. The last issue, though, is this issue about the board's decision to completely close the Kennedy Center on July 6th for 2 years to have a real rebuild. Everyone agrees renovations are needed, desperately needed, some like structural and repairs involving water leakage and maintenance systems and all that. But what has been more controversial, because until Donald Trump said, we're going to close the Kennedy Center, the plan had been to do those serious renovations while the Kennedy Center remained at least open in part and continuing its function, also created by statute, of engaging in the performing arts. And what Judge Cooper says there is, I'm not going to completely say you can't close it down, but board, in this exercise of your fiduciary duty and your duty to abide by the terms of the trust as established, you only looked at one side. You only got a presentation saying, we need to shut this down to do all these renovations. And you never examined the other mission statutorily mandated to have the center providing the performing arts. Basically, you need to go back and you need to do it again.
By the way, if you read the facts on that, I mean, he didn't say this is me. He's basically going, the reason you didn't look at it is because what happened here is you didn't have meetings on this. You didn't have any sort of normal things about what are the upsides and downsides. How much would it cost to close it completely? How much would it cost to close parts of it, but continue other parts of it, which is, by the way, the norm? And so you didn't do any of that. Why? Because what really happened here is that all these people pulled out the Washington National Opera, Renee Fleming, all sorts of incredible artists, long term contributors to the Kennedy Center, pulled out. The contributions to the Kennedy Center dropped through the floor, attendance dropped through the floor. So instead of having a failure on its hands, it was like, I'm taking my toys and I'm going away. That's what it reads like. And so the judge basically says, I have your number. So I'm sending it back to you, but it's going to come back to me. You better create a record that is bulletproof because I'm going to be looking at this. So this was a huge, huge win for the rule of law. Once again, it shows Congress had passed a law, but they need to be standing up. They're not, because this is a judge saying, I'm standing up for the rule of law and I'm standing up for Congress having determined what to do here and have a memorial for an assassinated president. And there's this real sense of, if I can desecrate it, I'm going to, because that's my brand. Sort of speaks volumes in terms of what's happening on one side and the rule of law that judges are upholding, whether it's Judge Maida, Judge Cooper, judge in Florida, all of these different judges saying that is not what the country is about.
Yeah. And last point I want to make on this is one more dig that Judge Cooper puts in when he's talking about the board's failure. It was like a preordained conclusion. He does use those words.
Yep.
He doesn't say everything you said, you glean it from the opinion, but he does say it was a preordained conclusion to shut down and that they didn't hear from the other side. And then he said the center's lawyers, who appeared to have exited stage left, also have a role to play because the duties discussed in this opinion are legal ones after all. Shall we take a break? We come back and we'll talk about another judge standing up, and that is in the SPLC case.
Sounds good.
Welcome back. Well, as promised, we are going to close out this episode by talking about what's been happening in the criminal prosecution of the Southern Poverty Law Center. That's a case we talked about several weeks ago. There are wire fraud charges and bank fraud charges that are allegedly related to the SPLC defrauding donors who thought that they were donating to an organization that stands up for racial justice, and instead, in the view of the indictment, which is just an indictment, just allegations, the SPLC was actually funding things like the Unite the Right rally in Charlottesville, Virginia, by paying informers to be part of the planning of that. Informers that, and this gets to the heart of what we're going to talk about today, informers that SPLC relied on over the years to get information about what extremist groups are doing and then provide that information to law enforcement. And that is the heart of the false statements that were made after this indictment by none other than the acting Attorney General, Todd Blanche. He had said on the same day the indictment was issued, importantly, there's no allegation or information in the indictment that suggests SPLC shared informant information with law enforcement. There's no information that we have that suggests that the money they were paying to these informants and these members of these organizations, that they then turned around and shared what they learned with law enforcement. To the contrary, or else we would have known from their own words that they had given money to these guys, and we didn't know. That is what Todd Blanche said publicly.
And he said that on Fox News.
That's right. So in comes the SPLC, and they moved the court to correct these false statements. They filed a motion where they explained that they had even reached out and met with the Department of Justice when they understood that the SPLC was under investigation, and supplied all kinds of information about its informant program, which it has been shut down for some time. And by the way, I'll say, obviously, Director Kash Patel, the FBI director, knew about the informant program because he had publicly announced, we're stopping this program of working with the SPLC. But they demonstrated in their submissions to the Department of Justice and in their conversations, according to them, with the Department of Justice officials, that this is the history of this program where they would share information with law enforcement. So they came into court and said, Your Honor, we need to get a correction of these false statements. Well, several days after the false statements that Todd Blanche made that we both just talked about on Fox News, he said something different. This time he said, also on Fox News, it is true that over the years, they, meaning SPLC, have selectively shared information with law enforcement. Okay, remember what he said before. There is no information that we have that suggests that they were sharing information with law enforcement. That's what he had said on April 21st. Now he says it is true that over the years, they have selectively shared information with law enforcement. That's well documented, and there's no dispute there. They aren't charged with any of that conduct.
Can I just say, that is what they're charged with. Like, it is literally true that's not what they're charged with, but the theory of the case is
You were committing this fraud.
you were committing this fraud and that you wanted these groups to succeed at their hate crimes, but you were just telling your contributors that you were fighting them. That's the Ponzi scheme.
That's right.
So the idea that you were giving the information that you were gathering to the government is literally the opposite of what is charged.
Exactly. The opposite, right? How are you actually trying to further the extremist groups' missions when you are channeling the information you get about them to the government, to the FBI?
So that they can take action against them, not in favor of them, against them.
That's right. And to prepare for potential acts of violence, all that kind of thing, right?
Right.
So the way this comes up in this short ruling by the court is the court has to rule on this motion to correct the false statements. And the court says that motion is now moot because Todd Blanche has retracted that. Now, put aside for a minute, I actually think the judge should have required that to happen in a legal filing and not just listen to Fox News. But the court says this April 26th public statement by Todd Blanche is sufficient to show that there has been a correction of the false statement. And so the request for relief in the motion is now moot. And then the court goes on to say, SPLC asks the court to order the government to not make any more false statements, follow rules related to extrajudicial statements. This reminds me a little bit of motions back in the criminal cases against Donald Trump, basically for what was called a gag order, but were really requests to say, don't let him go out there and tell a bunch of lies that get people in a position of being the victims of threats and things like that. Here, the judge, rather than granting that, starts to talk about the integrity of the judicial process being rooted in the obligations of and trust in the attorneys participating in it, has several lengthy quotes from cases.
From very famous cases about the obligation of lawyers in general to the court and to their duty of candor to the court. If you're a lawyer or a prosecutor, you're aware of these things. This basically is telling the prosecution, I'm not a fool here. Like, you have an obligation to the court to not engage in this conduct. And that while you have said, don't worry, we're not going to do it, you just did it.
That's right.
So I'm basically laying down a marker.
Yeah. You know, the court could have said, I'm going to grant that motion, but the court said, I don't have to grant that motion because the government has acknowledged it is well aware of its obligations under the law and the applicable rules and committed that it will act accordingly. And that's when the judge goes through all of these quotes, right? Saying, basically, like you said, I've got your number. I'm holding you to it. I'm not going to make an order because you're telling me you're going to obey the rules. And the judge concludes with, I think, a really great quote. We must return to the original principle that as officers of the court, attorneys are servants of the law rather than servants of the highest bidder. We must rediscover the old values of our profession. The integrity of our justice system depends on it. Then he goes on to say, like any officer of the court, the prosecutors are bound by their statements to this court. And based on that, the court won't give any further relief. So in many ways, what's unspoken here, this is the most important.
Yes. So there is a pending motion now by the Southern Poverty Law Center to dismiss the case for vindictive prosecution.
That's right.
And it'll be interesting to see where that goes. To me, it's not an exact fit. But one of the things that now that there is this quote corrected record is it's both given that Todd Blanche has now made a statement that quote corrects the record that is antithetical to the theory of the case. There actually is part of the indictment that actually also is antithetical to what is charged here because as the government knowing and acting on information from the Southern Poverty Law Center, I wrote an op-ed in the New York Times on Friday, in the hard copy on Monday. We're going to put it in our show notes. And it maybe fits the theme of thinking about a systemic reform. The general idea is that to bring an indictment, you only have to meet a very low standard of probable cause. The courts don't give a percentage of what probable cause is. But let's think about that maybe as 20%. I'm going to just give you a rough estimate. You don't need a ton of proof. It's a low level. And also, for a federal grand jury felony indictment, you do not have to get the grand jurors to unanimously agree. You only need to have a majority, 12 of the quorum. So a quorum is anywhere from 16 to 23 grand jurors. That's a lot of data for people.
Yes.
But you need 12. You don't need all of the grand jurors who are present to agree. Now, obviously, when you go to trial in a criminal case, everybody knows you need a unanimous jury beyond a reasonable doubt. So you have this huge discrepancy between low level of proof to just get a charge and high level of proof to have a conviction. Internal to the Department of Justice, there are rules that deal with that difference between time one, low level, and time two, high level. And it's not a rule that any of us really ever had to think about because it was so natural, which is like Mary McCord isn't going to be bringing a case or approving a case unless she looks at it and says, oh,
I can meet that high level.
I'm not going to let you go forward unless there's like a real lively prospect that you're going to be able to win at trial and on appeal, meaning that it's legally sustainable and that you'd be able to win.
And let me just break that down a little bit, right? That's a beyond a reasonable doubt by a unanimous jury. And that means that the government has the evidence, admissible evidence, to prove every element of the crime beyond a reasonable doubt. Because when a criminal case goes to the jury, they get instructions about, for each crime charge, there are certain elements that the jury has to find, and they have to find each of those elements have been proven beyond a reasonable doubt.
Unanimously.
Right. And so what is the point of getting a grand jury indictment on this minimal level of probable cause where you're like, you know what? I think I've got probable cause here. I know I can't prove this case at trial because this is definitely not good enough to convince a unanimous jury of every element. But I mean, I have probable cause, so I'm going to go ahead and go forward. You don't do that. It's a waste of your own time. It's also unprincipled and unethical and wrong. And you would only do that, as you point out in your op-ed, if you're kind of just trying to taint somebody or target somebody, regardless of what your ultimate success might be.
So the internal DOJ rule deals with this, and it says internally to the DOJ, you've got to follow this rule, which is don't bring a case unless you really have a good basis to believe you're going to win at trial. And none of us needed to be told that because it was just obvious in both morally, it was obvious in terms of just your own self-protective, like good law enforcement.
Yeah.
You just would never do it because you weren't thinking under Republican or Democratic administrations about just, oh, let's bring a case just to have retribution. But that's the problem that we're seeing is that we see cases like the Letitia James case, the James Comey Seashells case, the Southern Poverty Law case. We see other cases that they were bringing that they couldn't even get the grand jury to agree on, which is the 6 members of Congress. So they obviously weren't applying the internal rule. Now, internal DOJ rules are not laws. And so that means that the grand jurors are not told, oh, here's the standard that internally to DOJ they have to meet. The grand jurors are just told, is there probable cause? And so to deal with this time one, time two issue and the fact that we've got an internal rule, not a law, is my proposal, which I think should be bipartisan, and I'll tell you why, is that you just put into law essentially what that internal rule is.
What the standard is.
And so that means if, let's say, the standard is clear and convincing, it's a standard that's much closer to proof beyond a reasonable doubt. You could even have it be that it's not just a majority, but a greater number. But you'd essentially increase the standard at time one. So it's much more akin to what you'd have to prove at trial. And the reason that any good prosecutor should say fine is because that's what we're doing anyway. In other words, Mary is not authorizing an indictment or not doing one herself, and I didn't the same thing unless it already met that standard. So it's not going to hurt good law enforcement. And if you're the Democrats and you think that there was weaponization, by the way, as I do, that's going on now, or you're Todd Blanche and you think there's weaponization that went on during the Biden administration, and you're worried, as he said in the CPAC speech that he gave, that he's worried about what's going to happen once he's out of
Yeah.
office and whether he's going to get charged. The administration,
What a thing to say, by the way.
yes, unbelievable. But any administration should be saying, yes, let's raise the standard because we actually don't want retributive indictments. And so if you raise the standard, it doesn't get rid of the problem for good, but it certainly makes it a lot harder because what would happen is the grand jurors would be told it is not probable cause, just 20%. It is this higher standard that you need to meet. So you know how grand jurors didn't vote the members of Congress case? They didn't vote the Letitia James, reportedly.
And by vote, what you mean is did not return an indictment. Right?
Yes.
They rejected it.
Yes, right. And they rejected the sort of second and third Letitia James cases. It would increase the number of times that if a government tried to have retributive indictments, any administration, Republican or Democratic, it would make it much, much harder, but it wouldn't have any adverse effects on what good prosecutors are doing right now.
So I have two reactions. First of all, I do think it's a really good idea and very much worth exploring. And we shouldn't need it, but we do. It would have an impact in this way. And you're not suggesting beyond a reasonable doubt unanimous. You're suggesting clear and convincing evidence.
Exactly.
But it will mean, because a prosecutor right now can know they have the evidence to prove every element of a crime beyond a reasonable doubt, but they don't necessarily put that all in front of the grand jury because a grand jury is a more expedited process. You only have to meet probable cause. So what you might do is you put more of a selected excerpt of your evidence in front of the grand jury.
Because you want to sell above probable cause, but you don't need to sell all the way up to proof beyond a reasonable doubt.
Exactly. Yep. So I think it would require prosecutors to put more evidence in front of the grand jury. And right now they will oftentimes do it through like a summary witness, like an FBI agent who testifies about what people told the FBI agent because there are no rules against hearsay in the grand jury. And it might require, to get that hurdle, them to put on some more actual witnesses. So there would be impacts for sure, but they should not be insurmountable. And I think there could be some opposition even from prosecutors who believe that the standard is too low if they think this will...
Because it requires them to do more work.
That's right.
I mean, by the way, you're totally right, but it's more work versus unjust indictments.
Unjust indictments. No, that's right. The second thing is, and this has nothing to do with your proposal because I think it's a good and sound proposal, is there is another problem here that this would not fix. And that problem is, and we've already seen this because last week we talked at length about the misconduct in front of the grand jury.
Totally.
This won't address that, right?
Totally.
That is an issue as we're learning in case after case that things were improperly said to the grand jurors, vouching for evidence, misstatements of law, getting rid of grand jurors who disagree with the government. So that requires some other reforms. And I do think that it is worth thinking about what kind of standard there should be for a defendant to move the court to require that the grand jury transcripts be turned over at least to the court for review, because this is just happening too often.
I couldn't agree with you more. And if there's one theme that you see Mary and I talking about is not just what happened and putting it in context, but really thinking about what are things that can be done to help reduce this happening. What I'm proposing, Congress has the power to do.
That's right.
What Mary just talked about is something that the courts could do.
That's right.
And Congress could do.
And Congress.
And so these are all things that don't deal with executive power and the Trump versus United States decision, because we're both trying to figure out what can be done within the system we have now. Understanding, of course, you could think even bigger than this, but what can be done which is doable? By the way, I feel like I got the Mary McCord seal of approval. So that's a lot.
And I feel like we need to start working on proposal too. So
okay, I love it. I love it. Okay, so everybody, thank you very much for listening. Mary, it's always a complete, total pleasure. Remember, everyone else, that you can subscribe to MS Now Premium on Apple Podcasts. And you can get this show and other MS Now originals ad-free. You'll also get subscriber-only bonus content. And as a reminder, we are also available on YouTube. So head to ms.now/mainjustice to listen.
This podcast is produced by Vicky Vergolina. Nicholas Benuela Yodar is our associate producer. Bob Mallory and Hazik bin Ahmad Fared are our audio engineers. Katie Lau is our senior manager of audio production. And Aisha Turner is the executive producer for MS Now Audio.
Search for Main Justice wherever you get your podcasts, and follow the series.